right, good afternoon, everybody. Thanks for joining us today. And thank you for coming to the IP Lunch Club. My name is Mackenzie, and I'm one of the 6 team members of the Sandbox Center. For those who may not be acquainted with SBX, we're located online in downtown Barrie, and we connect people and their ideas to business resources so that they can create a better life through business. We're thrilled to once again be continuing our partnership with IP Osgoode's IP Innovation Clinic. Protecting the ideas and creations of artists, inventors, and business owners allows businesses to grow and encourages innovation. So for those who may not be acquainted with the IP Innovation Clinic, maybe you haven't attended our partners sessions held back in our space in the previous or last week's online session you may have missed, let me acquaint you with them. They're an innovation to market legal clinic staffed by law students and operated in collaboration with York University's Innovation York, Norton Rose Fulbright LLP, and the International Law Research Program at the Center for International Governance Innovation. It serves a clientele that is needs-based and underserviced, such as individuals or startup companies who do not have the resources to hire a lawyer, a patent agent, or other advisors. So under the guidance and mentorship of the supervising lawyers, Innovation Clinic Fellows provide one-to-one legal information services to inventors, entrepreneurs, and startup companies to assist with the innovation and commercialization processes. The partnership we hold is so incredibly unique to be able to provide the opportunity for students to have hands-on experience supporting businesses, and then similarly for businesses to have access to this expertise is such a win-win. So before I continue with introducing the IP Innovation Clinic team for today's session, we're grateful to have Barriston Law join us for this series as a presenting sponsor. The team at Barriston is not only an active and committed contributor to SBX on the regular, but continue to serve the local region when it comes to protecting business owners and improving innovation. So I'd like to introduce Alexandra Paul of Barriston Law to share a few words. Alex, thanks so much for joining us today.
Thank you for having me. So I'm an articling student at Barriston Law. We're a mid-sized full-service law firm. We have offices in Barrie, Collingwood, Bracebridge, and Huntsville. We've had a long-standing active presence in our communities that we serve, and we're just so excited with our partnership with the Sandbox. Now, today's topic is, I think, so important. The mechanics of filing a patent can be quite tricky and technical, and even a small error in your application can seriously compromise the value of your patent. So understanding how to file the patent, how to get the application done correctly, it will really add value to your business and your ideas. And I think that just having an understanding based off these presentations will be invaluable to anybody looking to get their patent going.
Absolutely. Awesome. Thank you so much, Alex. And thank you again to Barriston Law for sponsoring this series. Today, in part 3 of the IP Lunch Club, the team will uncover the basics of patent law and discover the roadmap for filing a patent and highlighted differences between patent regimes in Canada and the US. So if you have any questions throughout the session, please don't be shy. Use the Q&A features that's just in the bottom or the chat if you'd prefer, and we'll make sure to address them just at the end of the session. So without further ado, let's get started. I'll pass it over to Ashley of the IP Osgoode team to get us started.
Great. Thank you so much, Mackenzie. Welcome, everyone, and thank you for joining us at the IP Lunch Club. My name is Ashley Moniz, and I am a lawyer and the Assistant Director of IP Osgoode, home of the IP Innovation Clinic. Mackenzie has given you a wonderful introduction to the amazing work that the clinic does. I'm happy to be introducing today's topic and presenters on behalf of the IP Innovation Clinic. Our clinic fellows have worked hard to prepare these informative presentations, and they look forward to teaching you this afternoon about the mechanics of patents. If you have any questions, please enter them in the Q&A below, or you can reach out to us at the IP Innovation Clinic directly. This is the third of a 5-part series, and we would encourage you to come back to join us for the next 2 Wednesdays this month for our remaining sessions. At the end of our 5 presentations, we will distribute a survey about our presentations, and we encourage you to share your feedback about what you like and how we can improve these sessions in the future. After today's presentation, the Sandbox Center will circulate a recording of this presentation, as well as all of the available materials and links to the IP Innovation Clinic resources. The clinic has a particular focus on highlighting the creativity, intellect, and talent of Canada's underprivileged communities, and we hope that these sessions will offer some helpful insight to innovators who may otherwise struggle to access it. So without further ado, please welcome Christian, Tyler, and Bonnie.
Thank you, Ashley, and thank you to Mackenzie and the entire Sandbox team for having us. So as mentioned, we're going to be discussing the mechanics of filing a patent and patent law. So I'll be discussing some patent basics. Tyler will then be discussing filing a patent in Canada. And finally, Bonnie will discuss some similarities and differences between patent regimes and the patent filing process in Canada and the US. So a patent is a government grant to a time-limited, legally protected, exclusive right to make, use, and sell an invention. So as an inventor or someone who's seeking to get a patent, you file an application with the Canadian Intellectual Property Office, and that office will assess that application and determine whether or not your invention meets the requirements for a patent. If they deem that it does, then they will then issue you that patent. And the patent is essentially a monopoly on things you have claimed in your application, or the product or the process or whatever it is you've claimed in that application. So really you have freedom to do what you like with it. You can make that product and sell it. You can license your patent. You can sell that patent, or you can, you don't really have to do anything with it. You can just start to build your patent portfolio. So this patent, the term of the patent lasts for 20 years. And really it's an agreement to public disclosure. So when the patent is granted to you or the patent is issued to you, your information or the details of your invention actually become public knowledge. So anyone in the public actually has access to it if they choose to access it. What is an invention? So under the Patent Act, an invention is any new and useful art, process, machine, manufacture, or composition of matter, or any new and useful improvement in any of these areas. So that might sound a little confusing, and it really is a broad definition of an invention. And there are essentially 4 elements to what is considered an invention under the Patent Act, and I'll begin by discussing 3 of those. So in order for an invention to be patentable, the invention needs to be new, it needs to be useful, and it needs to be inventive, or in other terms, it has to be non-obvious. So we'll go through each one. New. Is the invention something that is actually new? And this is determined based on your filing date. So once the patent application is filed, from that date before, the Patent Office will assess whether or not there was any disclosure of that invention to determine whether or not it is actually something that is new. So disclosure can be both verbal at a presentation or a conference, or something that's published, like in a journal or a previous patent. So fortunately in Canada, we actually have a 1-year grace period, meaning that if you disclose the information or the details regarding your invention, then you have 1 year from that disclosure to actually file your patent. So I'll use the example of a door lock. So if my invention is a new lock for a door, and I go to a conference and I actually present all of the details of that invention, right then the time the clock starts, and I have a year from that date to actually file my patent or file my patent application. And as long as I file it within that year, I won't have any issues with it, with that disclosure that I discussed the details of at that conference. So that's new. And then there's also useful. So is the invention something practical? Does the invention do what the application says it will? And can someone who has skill in that field actually figure out what the invention does from your application? So really this is somewhat straightforward, but to put it into the door lock example, if my door lock, it can be screwed into the door, it has the door handle and the key can go in the slot, that's great. But if I claim in my patent application that the door lock actually locks the door, and the bar that goes out from the door lock into the door frame doesn't do that, and the door is able to open and close freely, we might have some issues here with whether or not my application is, or my invention is actually useful. Because I've said it's going to do one thing and it actually doesn't do that. Again, we could have some issues with whether or not it's useful. And finally, inventiveness, or as I kind of mentioned, non-obviousness. So this is determined through the lens of a person who's skilled in that field. So I don't know actually a whole lot about door locks, but the patent office may look through the lens of, say, a locksmith, someone who really understands the field and has skill in that area, to determine whether or not, based on all the information available prior to the filing date or to prior when you first file your patent application, it was obvious that your invention should be made or should be patented. So an example is with the door lock, it's a little bit tricky, but I would say the door lock goes into the door, it can lock the door, but there's no handle. Now, there's a potential issue here with whether or not someone like a locksmith would consider adding a door handle to the lock as one entity, whether or not that was obvious. So there really needs to be an element of inventiveness. And the last important, the last essential element of a viable patent would be that it's patentable subject matter. So not every invention is patentable, even though it's new, useful, and non-obvious. So a product is patentable, a product being, with the door lock, the physical component of the door lock and how they interact together. The process by which the door lock is made, the stepwise process, can be patentable. The machines used to assemble the door lock can be patentable. The composition potentially of a chemical lubricant used to ensure that the bar goes in and out of the door frame can be patentable. And any improvements in any of these areas, provided that they're new, useful, and non-obvious. And finally, there are some areas that are deemed are not patentable, or they're not patentable subject matter: scientific principles, professional skills, products of nature, mathematical formula. So it's a non-exhaustive list, and definitely a fact-specific exercise determining what is and isn't patentable. But in general, abstract ideas, abstract theorems are not going to be patentable. So with that, I'll turn it over to Tyler, who can discuss how to file a patent.
All right, thanks, Christian. So now that we know what a patent is, I'm going to explain to you the process of how to actually file a patent. Due to its complexity, it's highly recommended to hire a patent agent or an IP lawyer to assist you through this process. So we've outlined 5 steps for obtaining a patent that are set out on the current slide, and I'm going to be taking you through each of these steps in more detail. The first step is to perform a preliminary search. This is not actually a required step in terms of securing a patent, but it's certainly recommended. The idea behind performing one is to find out that if it's likely if your invention infringes on an existing patent. And if it does, there's no point in continuing to spend time and money to try to file your patent when it's ultimately going to be denied in the end. There's a few resources you can use to search for existing patents. These include Google Patents, the Canadian Intellectual Property Office, or CIPO, and the USPTO, and these are databases for Canada and the United States. And the IP Innovation Clinic does assist startup companies, entrepreneurs, and inventors by performing this step and giving legal information on an invention's patentability. So if you have determined that there is a good chance your invention doesn't infringe on an existing patent, the next step would be to prepare a patent application. Now, this is a very technical process, and the rules are set out in federal legislation, including the Patent Rules and the Patent Act. And at this point, you can obtain something known as an early filing date. And to do this, you must provide to the Patent Office 3 things. 1, an indication that a Canadian patent is being sought. 2, your contact information. And 3, a document describing your invention. Now, the components required to be submitted to obtain an early filing date do not make up the entire application. This slide shows all 5 components that are required. First is the petition, which is a formal request for the patent, and it contains the title of the patent and your contact information. Second, the abstract is a short description of your invention, which must be kept to 150 words or less. Third, a more detailed description of the invention is required, which contains all important parts of what you're protecting. Fourth, the claims are the elements of the invention that you wish to claim exclusive rights to. And finally, the last part of the patent application is the drawing section. And this is where you include diagrams of your invention that show every feature that is covered by your claims. Now, once all the documents are prepared, you can formally file your patent by submitting it to the patent office. And at this point, you will have to pay a fee of either $200 if you're a small entity, which is an entity consisting of 50 employees or fewer, or $400 is the standard fee. And once this is done, you can obtain, or you will obtain an application number and a filing certificate for your patent. And after filing, your patent is now pending. And 18 months after the filing date, the application is laid open to the public and a copy is put in the database. And at this point, you're required to pay maintenance fees on each anniversary of the filing date. And any time within 4 years after filing, the next step would be to request a formal examination of your patent, which requires payment of another fee of $100 or $200, depending on whether you're a small entity. And a patent examiner will look at everything included in your application, including whether the invention is new, useful, and non-obvious, as Christian mentioned, and whether the application was made using the formatting that was set out in federal legislation. Next, the examiner can object to claims in the application and will provide what's called an examiner's requisition, which is a report on the objections and the changes that are required. You can either make these changes, argue against them, or you can just abandon the application if you don't respond to the requisition within 4 months. If the patent is rejected in a final action, it automatically goes to the Patent Appeal Board. So finally, if the examiner has no more objections, your patent will be approved and you will receive a notice of allowance in the mail. A final payment will be required and your patent will be officially registered in Canada. However, to keep the patent running, you're still required to pay maintenance fees on each anniversary of the filing date. Otherwise, it will be deemed to expire before the typical 20-year period. And I'll pass it along to Bonnie.
Thanks, Tyler. So since many Canadian innovators may be interested in marketing their innovations in the US as well as in Canada, we thought we would do a brief comparison of the two patent systems. Next slide, please. Okay, so according to a report published by the Canadian Intellectual Property Office in 2019, CIPO received 36,162 patent applications in the year 2018. 46% of those applications were filed by entities based in the US, making the country the largest exporter of patent applications to Canada. Next slide, please. So in the same report, the top destination for patent applications filed abroad by Canadian entities were also looked at, and it was found that 68% of those applications were filed in the US. So all these findings show that understanding the differences between the two patent regimes is very important. And I'm going to expand on some of the key differences between the two systems. Next slide, please. So for a long time, the most fundamental difference between the two systems used to be the date that was relevant to the assessment of novelty and non-obviousness. In the US, novelty and non-obviousness were assessed as of the date of invention, whereas in Canada, the filing date was what mattered. However, as of 2013 and following changes made to the America Invents Act, the US also follows the first to file rule. And this makes it very important for applicants to establish a claim date as soon as possible in both countries. Next slide, please. So applications both in Canada and the US have a 1-year grace period since a public disclosure of the invention. The difference, however, is that in Canada, only applicant-derived disclosure would trigger the beginning of the grace period, whereas in the US, the grace period applies to all forms of public disclosure. Another key difference is that the Canadian grace period will begin when there has been a disclosure anywhere in the world, whereas in the US, the grace period is only triggered when there has been a disclosure in the country, meaning in the US. Next slide, please. So the US tends to be a lot more liberal than Canada when it comes to patentable subject matters. In theory, in the US, as long as the novelty, non-obviousness, and utility criteria are met, the invention is very likely going to be patentable. In Canada, however, there are restrictions set in place to prevent higher life forms from receiving patent protections. An example of a higher life form that is not patentable in Canada is a genetically modified mouse. These types of mice are often used in biolabs for experiments, and courts in Canada have ruled that they are not patentable. Next slide, please. So a common prosecution strategy in the US is to accept an imperfect or less than ideal patent application and later on introduce new matters to the pending application. This is what's called a continuation in part application. In Canada, there's essentially no such thing as a continuation in part patent application, and the applicant must file a brand new patent application if they wish to introduce new matter. Of course, if an applicant chooses to do so in Canada, they may face a rejection based on double patenting, since their previous disclosure in their old application could be cited as prior art by the examiner. Next slide, please. So another key difference is that in the US, the examination process of an application commences automatically, whereas in Canada, it must be requested. Also, unlike the US, there's no obligation on a patent applicant in Canada to voluntarily disclose all known material prior art to the patent office, and the applicant would only need to respond to requests made by the patent office. Next slide, please. So finally, in the US, maintenance fees are due only 3 times during the lifetime of a patent, during those 20 years. But in Canada, maintenance fees are due annually beginning on the 2nd anniversary of the filing date of the application. Next slide, please. So please keep in mind that the information we provided in this presentation does not qualify as legal advice. And Christian, if you could please go to the next slide. So you can see the IP Osgoode website address on this slide. Please check out our chatbot to get answers to your IP-related questions. And please use the email on the slide to get in touch with us at the IP Innovation Clinic. Thanks for listening.
Awesome. Thank you so much, team. That was a great presentation. We do have a couple questions in the chat if you guys want to get started. First, actually, I have a question because it was kind of on my mind after you mentioning the maintenance fees. What does that entail exactly? So you're paying the maintenance fees, but what is the maintenance behind the patent that's being done? Could you explain that a little further?
Yeah, for sure. So basically, it's like a very complex process from start to finish. So maintenance fees, basically, it's just like the fees that are involved, like in the patent office, because there's so many different expenses that go along with it. And it's just the patent office, like small fees that the patent office has to undertake to complete the process. Okay,
so just kind of like keeping up with any admin on the back end of things that would have to do with your patent. And gotcha. Okay, perfect. Thanks. Somebody's asking, how long does the patent registration process take?
Yeah, so this it varies greatly depending on a number of factors. The average from start to finish is about 3 to 4 years. But again, it varies greatly depending on the complexity of your invention or and also the amount of back and forth there is between you and the patent examiner based on the requisitions.
Somebody's asking, what information should I prepare before contacting a lawyer to file a patent? What would need to be gathered?
I could probably weigh in on this. So I would say for you to sort of get the process going in a smooth way, you should know your invention very well. You don't necessarily need to know why it works, but you need to know how it works and how each component works and how all the components together sort of interact. It's also important to do a prior art search to see what's out there. And that's what we do at the clinic. So we help you with prior art searches. We look into databases in the US and Canada and all over the world. Mm-hmm. And we help you with that.
That's awesome. Perfect. Somebody else is asking, why do you think Canadians file so many more patents abroad than in Canada? Do they receive more benefits or protections abroad? Are there fewer barriers to registration? What would your opinion be?
I think it very much depends on the market in those countries. I think the reason there are so many Canadians who file patents in the US is because just the size of their economy. There's a lot of potential for profitability. I don't think it's necessarily because of certain strict barriers in the Canadian system. I just think it's because of the economy in the US especially.
Do you guys want to add anything?
I would just add that even though that is the case, I know there's been a push over the last couple of years for Canadian inventors to maintain their IP in Canada and for IP to stay within Canada, not just on a federal level from the Canadian government, but even in Ontario. I believe it was in July. There was Doug Ford is putting together a team to kind of push for IP education in Ontario and to ensure that we do our best to maintain IP in Canada. So maybe even though that might be the case, hopefully there's greener pastures for Canadian inventors to kind of keep their IP, particularly patents, in Canada.
Definitely. Thank you. Somebody's asking, how can I protect my patent if I feel it has been infringed? So I was actually wondering this as well. So like if you come across something like, this is exactly like what I have. What's your first step to making sure that somebody doesn't infringe upon what you've already went through the process to do?
So I can answer that question. I think that first and foremost, it's a very fact-specific exercise. So it's going to very much depend on the type of invention you have and the details surrounding that invention. I think first and foremost, it's important to contact a lawyer. If you do have an invention that has a patent attached to it and you think that your invention is being infringed upon, or your patents are specifically being infringed upon, the first step would be definitely to contact a lawyer, because then they can help give you advice on the appropriate way to proceed and help develop strategies to optimize remedying this infringement. So because patents are only able to be enforced in a specific jurisdiction, so if you get a patent in Canada, you're only going to be able to enforce that right in Canada. So it's kind of tricky if, say, we have our patent in Canada and then a similar invention or potentially an infringement is occurring in another country. Enforcing that right is going to be a little bit tricky. So this kind of goes back to the idea that definitely based on your circumstances and the point in which you're developing your business, you can properly assess how to best protect. And obviously, in an ideal world, the more protection, the better. Mm-hmm. So there's something called the PCT, or the Patent Cooperation Treaty. And while this isn't a international patent, it is kind of it's a way that you can protect your patent in multiple jurisdictions. It still requires an initial filing, and then you'll have to enforce those rights in those specific jurisdictions, which will cost money and take time. But it is kind of a nice way to protect your rights in those specific countries that have signed that treaty. And normally, if there is someone infringing your patent, if you have a Canadian patent, someone's infringing in Canada, you speak to a lawyer, often they can send cease and desist letters. You can get injunctions to make them stop doing it if that's what you're looking for. And of course, under the Patent Act, if you have a patent and someone's infringing it, you're able to sue them for damages that can typically be in like a monetary remedy for potential income or market share that you've lost.
Awesome. Is there an instance where you should be, say you're in the process of filing the patent, or you have a patent and that you should be like displaying that, say, online, because now a lot of people are going digital? Is there an instance where you should have to display that, or no, do you not have to?
That's a good question. I think that's going to be, again, a very fact-specific exercise depending on the type of invention you have. Kind of going back to the disclosure element of getting your patent originally, disclosing your patent before you filed could actually be more detrimental to actually acquiring your patent. Because as soon as you, and Tyler, you can correct me on the date, at that 18-month mark, the patent is then open to the public, and then that information will be available online for whoever can see it to use it. So that's a good question. It might need to be something to consider from legal advice, how the best strategy to move forward to ensure that people know you have a patent on your product. But really, kind of all leads back to the idea that if you're able to, more protection in more jurisdictions is obviously going to be ideal, but that's obviously not the case for everybody. So the clinic always open for anybody who needs that initial patent search or trademark search even, and can help somewhat reduce those costs. So hope that somewhat gets that.
That's perfect. Yeah, thank you. Yeah. If Bonnie or Tyler has anything to add, feel free to jump in. The next question we have is, how can I retain the clinic services, and how much of the patent filing process can the clinic help me with?
Sure, I can answer that question. Oh, sorry, Bonnie.
It's okay, go for it.
So retaining the clinic services is very straightforward. On our website, iposgoode.ca, under the clinic innovation clinic tab, there's a become a client, and you can read through some of the aspects in a little bit more detail of what the clinic can offer. And then there's actually a link that you click and you fill out essentially an online form, and it will take your contact information, details of your very, very minor details of your invention, because obviously we don't want you to disclose anything that could potentially, again, lead to issues with you getting a patent. And then we begin the process of reaching out to you and seeing whether or not what you're looking for and what your situation, because we are really a needs-based clinic. As long as you fit the mandate of the clinic, then we'll be able to take you on as a client. And really, specifically in a patent situation, we're able to help with a prior art search. So that goes with the kind of what Tyler was mentioning with the preliminary search on Google Patents using the Canadian patent database. We're able to look at what patents or even just any general information that's out there that may be related to the patent you're looking to get or to your invention. And so we can help you assess to what degree or to assess essentially what is already out there in the public sphere. And then you can take that information. You can obviously use it in going forward and seeking independent legal counsel. But really, it's meant to give you a sense of whether or not it's worth pursuing getting a patent, and hopefully in the end it could potentially save people money because it is such a expensive process.
Absolutely. Awesome. Thanks for that info. The next question we have here is, a patent valid in every country, and how are patent rights enforced outside of Canada? So I know you guys touched on this, but if you could maybe circle back, that would be great.
Yeah, I could answer this one. So there's this thing called the PCT, the Patent Cooperation Treaty, that is signed by many countries. I would say all industrialized countries are party to this treaty. When you choose to file a PCT patent application, you basically put a placeholder in all those countries that are party to the treaty. It doesn't mean that you get an international patent. There is no such thing as an international patent, but you give yourself an 18-month period of deciding whether you want to pursue a patent application in countries other than Canada. Obviously, those patent applications have to be pursued independently. But yeah, so in short, there's no such thing as international patent, but there are ways to sort of ease the process.
If I patent a product, can people make changes to my invention to get around my patent? And if so, how big does the change have to be in order for them for this to be allowed? Who would like to take that?
I can try my best to answer that. So, like I mentioned in when we were discussing kind of what is patentable subject matter, what seemed to be an improvement, potentially even to an already existing patent, can potentially be patentable as long as it still fits that criteria of new, useful, and inventive or non-obvious. So yeah, if there is a way to improve an already existing patent that is potentially itself patentable, the degree of separation from the already existing patent, or I guess the degree of inventiveness, is really, again, kind of a fact-specific exercise, and is going to be very dependent on the type of invention and the type of improvement that's going to be made on that invention. I think it's a little bit easier to imagine something like the door lock example I gave, because it's a physical thing that a lot of people are familiar with. But something like potentially software that not everyone is super familiar with, it can get very technical. So if there are issues with whether or not that's infringing versus whether or not that would be a new patent, again, really important to contact legal advice if this is a genuine concern, and to make sure that if you're either you hold the original patent to make sure it's not being infringed upon, but if you're looking to get the new patent still in the same manner, you really want to ensure that you're not going to be infringing someone else's. So contacting legal advice to make sure that you're not doing that is super important.
We have one last question here. So if anybody has anything on their mind at all, feel free to jump it in the Q&A and chat. We have about a couple more minutes left. So would love to get your questions in. The last question we have here, somebody's asking, should I file for a patent application if I intend on making and selling the product myself?
I think kind of off the cuff, that sounds like a good idea. Again, so the patent itself is really a monopoly on that specific area. So if you file for the patent, you get, and it fits all the requirements, the patent is issued, you now have this monopoly in that area. So you can now make, use, sell, license, all of these things kind of how you see fit. So a patent, or at least getting a sense of how you would be able to go about getting a patent through things like the clinic's prior art searches and that type of thing, is kind of a good step in order to protect your business and to ensure that no one else is going to come in and start making either a similar or the same product and then take potentially part of your market share. So it really depends, again, on your invention, on your business strategy, on the point in your business or potentially in your product that you're currently at, as to whether or not you're going to take the steps to fill out that application. But if you're looking to protect your business and make, use, and sell your product, then it's definitely something to consider and can be really an asset to ensuring that you're protecting your business.
Yeah, I think Christian covered that pretty well. It is worth noting as well that it's a very expensive process, so it would depend like where your business is at. Like Christian mentioned, on average, it could cost anywhere from 10 to 20,000 and can be upwards of 50,000 depending on how complex it is. So that's also a factor to consider.
Just to add to what was said, if you start selling the product, you're basically disclosing it to the public. So as soon as you start selling, the clock sort of starts running. So yes, I would say that pursuing a patent application would probably be best.
That's great. Thank you, guys. I loved all of that feedback. And somebody's asking, will today's session be recorded for viewing at a later time? Absolutely, it is right now. And as Ashley mentioned at the beginning, we will be sending this out to everybody who registered. So for some reason, if you couldn't make it, you will get this as a resource so you can refer back to it as well. Thank you so much, team, for being here today. Your insights were incredible. And I hope everybody who joined us today was able to take away some insights that you can apply to your business as well. So thank you again to Alex from Barristan Law for joining us today. We encourage you to join us next week, same time, for part 4 of the IP Lunch Club, where we'll be tackling overcoming intellectual property issues faced by artists, writers, and designers. So the team's going to provide an overview of relevant Canadian laws associated to or with the protections afforded to artists, writers, and designers under the Copyright Act. It may seem like a silly question, but understanding and discussing what is art will be helpful when it comes to protecting your creative ideas. Thanks so much, everyone.